Hi, I'm attorney Ben Schwartz. Today we're going to continue with a series of videos relating to hit and run car accident cases. And if you've watched any of our prior videos, you know that if you are the victim of a hit and run case and the at-fault driver flees the scene and is never caught, instead of pursuing a case against that at-fault driver, you go to your own insurance company, your own auto insurance company, and make a claim for benefits or UMBI benefits, uninsured motorist bodily injury benefits, and the or UMBI insurance pays you what you would have gotten from the at-fault driver had you been able to identify them. And so we're continuing on with our series of questions. Today's question is, I was involved in a hit and run car accident in the parking lot of my job. Is that a car accident case or a workers' comp case? And the direct answer is it's both. If you're working on the job, you're in the parking lot, you're a pedestrian, you're walking through the parking lot, and a car comes and hits you and then flees the scene, then you have the right to sue that negligent driver. You have a right to make a car accident claim against that negligent driver's auto insurance. The problem is, if they fled the scene and no one ever catches them, you can't make a claim against them because you don't know who they are. You can't make a claim against their auto insurance because you don't know what insurance company it is. And so what you would do is you would go to your own auto insurance company and make a claim for uninsured motorist or uninsured motorist bodily injury benefits, and that or UMBI claim would pay you what you would have gotten from the at-fault driver's insurance company. Now, if this happened on the job, on the employer's premises, while you were at work, you also have a right to make a workers' comp claim. So under workers' compensation, you would be entitled to things like medical payments, payment of your medical bills relating to the injuries that you sustained in this accident. If you are out of work as a result of those injuries, you would have the right to make a claim for what's called total disability lost wage benefits. If you have a permanent impairment to a body part, you'd have a right to make a claim for permanent partial impairment benefits. You would have other rights too. Let's say if you have a scar, a surgery scar, or a scar from the trauma, you would have a disfigurement claim under the workers' comp statute. You'd have a right to get things like compensation for mileage going to and from your doctor's offices and your therapy appointments. And so you have both a claim and a workers' comp claim. Now the interesting thing about this is, if it my office handles these types of cases mainly in the Mid-Atlantic region, New Jersey, Pennsylvania, Delaware, Maryland. Right now, as we're shooting this video, we're in the Wilmington office in Wilmington, Delaware. So if this were to happen in Wilmington, Delaware, you would be able to make both claims, and technically you would get a double recovery. And people say, well, how is that fair? You get your pain and suffering and compensation for permanent impairment from your claim, and you get compensation for permanent impairment from workers' comp too. Like, how is that right to have the same thing coming from both insurance companies? And my answer to that is, if you paid your premium on your auto insurance, you paid for insurance coverage to pay you back compensation for permanent impairment if you are injured in an accident with an uninsured driver. And under the workers' comp claim, your employer paid that premium to get compensation for you if you're injured on the job. And so when you look at it this way, the insurance companies have collected premiums, in some cases, for years and years in order to provide those benefits. So my view is it's not unfair to make two claims at the same time and get a double recovery. It's like if you went out to a restaurant and you ordered two meals and you paid for both of them, you should get the 2 meals, and no one should tell you don't eat 2 dinners. As long as you paid the premiums, I think you ought to be able to make claims with both insurance companies, even if it's for the same type of injury or the same type of damages or same type of claim. So there you have it. That's my answer to the question of whether this is a UM claim or a workers' comp claim. I hope you found this video to be informative and interesting, something to think about. My name's Attorney Ben Schwartz. If you have questions about uninsured motorist claims, about hit and run accidents, car accidents, or personal injury cases or claims in general, feel free to contact me. You can get a hold of me through our Facebook page. We're at facebook.com/Schwartz and Schwartz. You can also send me an email. My email address is ben.schwartz@schwartzandschwartz.com.